Should I testify at my preliminary hearing? Imagine standing in a courtroom, facing a judge and prosecutor, wondering if speaking up is the right move. That moment can feel overwhelming, but knowing what to expect can help you decide. A preliminary hearing is not a trial. It's a step where the judge decides if there is enough evidence to move your case forward. The prosecutor presents evidence, and witnesses may testify to show probable cause. The defense can challenge this evidence but usually does not need to present its own case at this stage. Deciding whether to testify depends on your specific situation. Usually, it's advised not to testify at a preliminary hearing. This is because anything you say under oath can be used against you later. If your words contain inconsistencies or admissions, it might strengthen the prosecution's case. Testifying can also open you up to cross-examination. The prosecutor will ask questions to test your story and credibility. If they find contradictions, it could hurt your defense. Your attorney will review the evidence and decide if your testimony might help or harm your case. In most cases, your lawyer will recommend against testifying unless there's a clear reason. For example, if you need to explain a fact that the prosecution's evidence doesn't cover, or if you have a strong defense that requires your direct input. Your lawyer will prepare you thoroughly to ensure you understand what to say and what to avoid. Remember, the main goal at this stage is to challenge the prosecution's evidence. Your attorney can cross-examine witnesses and argue that there isn't enough proof to proceed. If the evidence is weak, the judge might dismiss the case or reduce charges. So, should you testify at your preliminary hearing? Usually, it's safer to relying on your lawyer's advice and not testify. They will handle challenging the evidence and protecting your rights. If they believe your testimony is necessary, they will prepare you carefully to avoid risks. In the end, trusting your attorney's judgment is your best move. They know how to navigate this process and will guide you on whether speaking up will help or hurt your case.